Hey, perfect students, civic education students, welcome to Civic Education Online Lessons, January 2023 with Knowledge World Academy. I am your perfect two times tech Gilbert CJ, and in this video, we are going to look at a very interesting and very important topic. Guess what? Legal system. So this topic is very important. You have to know your rights. Sometimes you may commit a crime, but you don't know these things. How should they take place? So this is legal system for you. So under this topic, we are going to look at the following. One, we'll define what law is and the legal system. Apart from that, we'll look at the elements of a good legal system. Sources of law in Zambia, criminal and civil cases. So we are going to look at 4 things in this video. Okay. So what is law? What is law? Simple question. What is law? So a law is a set of rules. A law is a set of rules that a society develops in order to control the behavior of its members. So wherever you are in your community or in your society, you've got rules that regulate the behavior of each and every member of that society. For example, we've got rules like do not steal. You are not supposed to sleep with another man's wife or another woman's husband. That is not allowed. So those are the rules. Now, when we put them together, we are forming what we are calling a law. That is what? A law. Great. Now, what is the legal system? The whole system now of enforcing the law. So this involves the rules that make up laws. So here we are talking about the law itself. When we talk about the rules, then we are talking about the law, because when we combine these things, we'll come up with a law. So the legal system involves the rules that make up laws and the institutions that administer the law. So when we put together the institutions such as the courts and the police service together with the law itself, that's what we are calling the legal system. That is the legal system. So I hope you now understand what a law is and a legal system. So now, how should this legal system be? How should it be? So let us look at the elements of a good legal system. Elements of a good legal system. So the first one is that a good legal system must be simple. What do we mean? The law must be written in a language that is understandable by a large section of people. It should be written in a simple language, a language that is understandable. 2, a good legal system must be comprehensive. It must be comprehensive, meaning it should attempt to cover all areas of disputes. It should not leave gaps. It should attempt to cover all areas of disputes. A good legal system must also be certain. It must be certain. Citizens ought to know, or citizens must know what is prohibited by the law. It shouldn't be written in a language that is only understandable by a small section of people. The law must be known to the citizens. It should be certain. It should be sure. The good legal system must be accessible. This means that it must always be readily available for the citizens when they want to know what is contained there. Have you ever seen the Zambian Constitution? If you have seen it, then it is accessible. If you have not seen it, then it is not accessible. So a good legal system must be accessible. That's what we are talking about here. Great. We are still looking at the elements of a good legal system. A good legal system must be flexible, meaning it should change with time. It should change with time. For example, in the past, women used to dress decently, but now, as you can see, the dressing has changed. So the law should change with time in order to suit the current affairs, so what is taking place on the ground. The last one is that the good legal system must have moral values. Moral values. What do we mean by moral values? The law should reflect the moral values of a society. it should reflect the moral values of a society. For example, just our nature, like our values as Zambians, we don't allow sleeping with another man's wife. We don't allow stealing. So those are our moral values. And these are the things which are contained in what? In the Constitution. So the law must reflect the moral values. This is what we mean. So these are the 6 elements of a good legal system. If it contains this, then just know that it is a very good legal system. Great. So let's proceed now. From the elements of a good legal system, we are now going to look at the sources of law in Zambia. Where did we get the law from? So first of all, let me tell you this. Zambia uses a dual legal system. Zambia uses a dual legal system. Why? Before colonialism, you all know what colonialism is. So before colonialism, Zambia was using customary law. Now, after 1980, Zambia started using the British law. So it combined the customary law and the British law. So Zambia uses dual what? Dual legal system. Now let us talk about the sources of law. The sources of law. The first one is the English common law. The English common law. So the English common law came from England. You're wondering how? How? Okay, great. So the English common law came from England. So this happened in 1066 AD when King William the Conqueror united England. So this king sent his judges in the country to collect cases, to collect all cases and to codify them. So from that act, they came up with a law that they were calling the English common law. Later on, England imposed its law on the colonies such as Zambia. So Zambia was the colony as at that time. So we also inherited the English common law. So this came from what? England. Great. Apart from the English common law, we also have legislature. So this is the lawmaking body, the biggest source of law in Zambia. The lawmaking body. This is the what? The legislature. So it makes 3 types of laws. The legislature makes 3 types of laws. The first one is the constitution. The constitution. Secondly, the acts of parliament. Then we also have delegated or subsidiary laws. So let us look at these 3 types of laws made by the legislature one by one. The constitution. The constitution is the supreme law of the land. Any law that does not conform to the constitution, then it is invalid. So the constitution is the supreme law of the what? The land. Then the acts of parliament. So these are laws that are made by bills passed in what? In parliament. So what is parliament? You may be wondering, what is parliament? Parliament is the combination of the president and the National Assembly. These things, the 2 things, make up what? Parliament. So how do they make the laws? The acts of parliament. So this starts by reading a bill in parliament, or in the National Assembly, we may call it. The bill passes through 3 stages of reading before it is sent to the president for either assent or veto. Veto. V-E-T-O-E. Veto. So if the president assents to the bill, then that bill is gazetted and becomes the law. But if the president vetoes the bill, meaning he or she has not signed, he or she has not accepted the bill, so the bill will be sent back to what? To parliament. Now, what happens when the bill is sent back to parliament? Parliament can either debate the bill or make further changes or send it back to the president in its original form. Now, when this happens, whereby they send the bill back to the president in its original form, the president has only 21 days in which to either assent to the bill or dissolve parliament in order to pave way for new elections. The third one is the delegated or the subsidiary laws. So these are laws which are made by cabinet ministers. For example, the Minister of Education can make a law to abolish the wearing of uniforms in schools. So those are the subsidiary laws. Apart from the legislature, we also have case law. Case law. So case law is the second largest source of law in Zambia. The largest is the legislature, then followed by case law. So under case law as the source of law, the subordinate courts follow the appellant court's lead. Let me simplify this for you. When subordinate courts are judging upon a certain case, they will consider how that certain case or how that case was judged upon in the superior courts. They consider how that case was judged upon in the superior courts. The superior courts that we have are the Supreme Court, the High Court, and others. So they consider how a case was judged upon in the superior courts, and that's how they will judge it as well. They will just follow what is there. That is the case law. Apart from the case law, we also have international treaties. So some international treaties like the Universal Declaration of Human Rights, the International Covenant of Economic, Social and Cultural Rights, these things, some of the contents there are sources of law. Now, those things do not automatically become law in Zambia. They do not automatically become law. Parliament has to adopt them. That's how it is for the international treaties. The last one is the customary law. So this is just the law based on customs of a society, and they are not codified. So these are the 5 sources of law that we have. Civil and criminal cases. Away from the sources of law now, let us look at the civil and criminal cases. So when they take you to court, or when you commit a certain crime, do you know whether that is a civil or a criminal offense? So here you are going to understand this. So what is a case? First of all, we have to define what a case is. A case is a matter being examined or judged in the court. That is a case. Now, let us look at a civil case. So a civil case is a wrongful act that only affects the parties involved. It only affects the parties involved. For example, failing to settle a date. Failing to settle a date. That only affects the 2 people or the 3 people involved in that date. For example, Mwanza borrowed money from Chanda. How does that affect Gilbert if Mwanza fails to settle Chanda? They are just the 2 of them. So that is a civil case. It only affects the parties involved. That is a civil case. Now, what is a crime or a criminal offense? So this one is the opposite of that one. This is a wrongful act that affects the interest of all members of the society. So for the civil case, it only affects the parties involved. But for a crime or for a criminal offense, it affects the interest of all the members of the society. So now, for a case to be deemed a criminal offense, it has to contain these 2 elements. There are 2 elements of a crime. The first one is the actus reus. This is the Latin word. This is a Latin word. Actus reus and mens rea. So these are the 2 elements of a crime. When these are there, the court will not to say this is a what? A criminal offense, and it's not a civil. So what is actus reus? The first one. This is the wrongful act committed, the action performed. For example, on murder, there is the action of killing. What did you use when killing? Maybe you used punches, or you used the knife, or you used the gun. So there is the action of killing that person. So that action is called the actus reus in Latin. Then we have the mens rea, the second element of a crime. So the mens rea is the intention or desire to harm. The intention or desire to harm. Did you plan to do that? Did you plan to kill that person? Was there the intention, the specific intention of killing that person? That is called mens rea. So for example, let me talk about the same murder, killing someone. You use a gun. Now, did you plan to use that gun in order to kill that person? Did you intend to do so? Did you plan it in your mind to say, I'll go and kill Mr. Gilbert today? Did you plan it? Then that is the mens rea. The other terms referred to this are: one, blameworthy state of mind, blameworthy state of mind, or malice aforethought. All these terms simply mean the intention or desire to harm. So do not be confused. They may use aforethought, malice aforethought, blameworthy state of mind, guilty state of mind. They are simply talking about the mens rea, which is the desire or the intention to cause what? Harm. So these are the two elements of a crime. Now, let us talk about the classification of crimes. These crimes are classified. So there are two things here. We have basically classifying these crimes and specifically. So let us start with basically. Classification of crimes basically. So basically, crimes are classified into two classes. We have crimes of specific intent. We have crimes of specific intent and crimes of basic intent. What are crimes of specific intent, students? So crimes of specific intent are crimes committed with specific intention. With specific intention. You just intended to do that. For example, theft. You can't say I didn't know what I was doing when I was stealing. No, that's not possible. Robbery, defilement, rape. No, I didn't know what I was doing when I just found myself raping her. No, that's not possible. You should intend. Something should click in your mind. I think this is great. I have to do this, you see. So there is that planning in your mind. So okay, I'll go and do that. So that is a crime of specific intent. Murder and other cases. Then we have crimes of basic intent. So these are crimes committed through recklessness or from a sudden impulse, or let me simply say, not or without intention. You didn't intend to do that, but you have committed a crime. But you didn't intend or you didn't plan to commit that crime. For example, you have killed someone, but you didn't intend to kill that person. How? Maybe you have hit that person with a car. You can't get into your car and say, today I'll hit the person to death. That is not possible unless otherwise. So examples of crimes that are of basic intent are: one, not stopping at a stop sign. Maybe you are just driving speed, then you fail to stop at a stop sign. So maybe it was just from a sudden impulse. The other one is manslaughter. So let me explain the difference between murder and manslaughter. Both involve killing someone. But for murder, you intend to kill that person. It is done with the intention. You intend, you plan to say, okay, I'll kill Gilbert today. That is murder. But when you kill a person without intention, you didn't intend to do so. That is not murder, but manslaughter. Great. Now, classification of crimes specifically. Classification of crimes specifically. So that was basically where we have crimes of specific intent and crimes of basic intent. So now specifically we have three classes of crimes. We have misdemeanors crimes. These are petty crimes. When I say petty, I mean small crimes such as common assault, littering, and others. So these are just small crimes known as misdemeanors crimes. Then we have felonies. Felonies. These are serious crimes now. Serious crimes such as defilement, rape, treason, aggravated robbery, among others. Murder, all those are felonies. Serious what? Crimes. Then we have the statutory crimes. Statutory crimes are those crimes committed contrary to what is written in the statutory instrument. So let me simply say, to what is contained in the Constitution. Crimes committed contrary to what is contained in the Constitution. For example, voting twice in an election. That is not what the Constitution says. So that is contrary to what is there. Rigging, election rigging. That is contrary to what? To the statutory instruments. So these are the three classes of crimes specifically. So basically we have crimes of specific intent and crimes of basic intent. But specifically we have misdemeanors crimes, felonies, and statutory what? Crimes. So this is the end of part 1. We have looked at the law, legal system, sources of law, and other things. In part 2, we are going to look at the legal institutions such as the courts and other things. It has been your perfect tutor. Please do not miss the part 2.